The Athens Board of Zoning Appeals operates according to the following procedure. The chair will name and describe the case. The zoning administrator or secretary will state the basis of the objection and any applicable facts or conditions pertaining to the case. The appellant or their representative will give reason why the appeal should be viewed favorably. Anyone wishing to speak in favor of the request will be heard. Anyone wishing to speak in general comment will be heard. Anyone wishing to speak in opposition will be heard. If necessary, the appellant or their representative will offer concluding, summary, or rebuttal remarks. Testimony from the floor shall be closed. The board will deliberate and render a decision. According to Athens City Code, Section 23.07.03b, the board has power to grant variances from the strict application of the code, provided the variance will not be contrary to the public interest, the spirit of the code is observed, public safety and welfare are secured, and substantial justice is done. According to Athens City Code, Section 23.07.10c, variances from the code shall not be granted unless the board makes specific findings of fact, based directly on the particular evidence presented to it, that the standards and conditions imposed in this title, if applicable, have been met by the applicant. Exceptional circumstances. There are exceptional or extraordinary circumstances or conditions applying to the property in question or to the intended use of the property that do not apply generally to other properties or classes or uses in the same zone. Practical difficulty and undue hardship. Because of exceptional or extraordinary circumstances or conditions pertaining to a specific piece of property, a literal enforcement of these regulations will result in practical difficulty or undue hardship that is unnecessary to the achievement of public purposes. Preservation of equal property rights. Literal interpretation of these regulations would deprive the appellant of rights commonly enjoyed by others in the same zone and the same vicinity, while a granting of the requested variance will not confer on the applicant any special privilege that is denied to other properties in the same zone and the same vicinity. Minimum variance. The variance granted is the minimum variance required to make possible the reasonable use of the property. Absence of detriment. The authorizing of such variance will not be of substantial detriment to adjacent property and will not materially impair the purpose of the zoning code or the public interest. Not of a general nature. The condition or situation of the specific piece of property or the intended use of said property for which variance is sought, one or the other or in combination, is not of so general or recurrent a nature as to make reasonably practicable the formulation of a general regulation for such condition or situation. Any person, resident, or officer, department, or appointed body of the City of Athens, aggrieved by a decision of the Board, may petition the Athens County Court of Common Pleas concerning the illegality of the decision. Such petition must be filed within 30 days after the mailing of the decision of the Board to the applicant. Thank you.
Appellants are requesting a variance from ACC 23.10.01 Table A, a schedule of bulk controls, to allow an addition to a house with a rear yard setback of 12 feet, where 30 feet distance is the minimum required. Mr. Paskey, the way I understand the addition is like two sections. One is 16 by 25 and one is 8 by 40, right?
Yeah, it's primarily all one addition. I'm a little bit familiar with this site due to a lot split that we did across the street a couple years ago. Ed, you need to be down here. I'm a little bit familiar with this site due to a lot split we did a couple years ago. The actual road that runs to the right-hand side of the house is a city platted right-of-way that used to run all the way through. It used to be part of what I believe the old Mechanicsburg subdivision years ago. And even though it says on here it's a 12-yard, it is a 12-foot rear yard setback after the addition. But the fence line that you will see after the addition is approximately 26 feet away from the back. But that is on, best we can tell without making them get a survey, as part of state property. It backs up to the land that the ODOT took years ago when they put the Route 33 bypass in. So they kind of took some of the land there to put the freeway in, and that reduced their rear yard. And so they're wishing to add on and not have the rear yard setback required, so they're asking for a variance for that.
So what you're saying is what the appellant said in their statement is their understanding that when the highway cut through our neighborhood, property lines were dissected to accommodate the path.
They were dissected a lot through there. I don't know if there was one that was dissected. If you look at the old plat, I mean, there was a whole subdivision at one time laid out back through there that is now all vacant properties that the state took the land. So
Dissected and was reduced.
I can't say this particular property was, but a lot of that area was. So I don't know in particular if this one was. I do not have the original. I did when we did the lot split, and I didn't think to pull it out. The original survey of everything that was out there where the freeway went through.
So also you're saying that it's state property, not city property, correct?
Behind their house.
Correct.
Behind their
Not
house.
the city right away. I'm not talking about that. I'm talking about behind the house.
That is correct.
To the rear of the property line.
Yes.
And we haven't heard anything from the state complaining about this.
No.
Did you say there was a fence 16?
There's a fence line approximately 26 feet behind the addition they want to build, and that's the actual fence line for the state, but it's not exactly on their property line. Best we can tell from the county auditor's overlay. I mean, if we actually got it professionally surveyed, or if they did, that we might find it's a little different. But I think all in all, it's generally pretty close.
So you're saying it's 26 feet from the current rear of the house?
Proposed to the fence line.
To the fence line?
Yes.
Okay.
I thought it was a little bit less maybe, because this looks like about 35 feet from the back of the house to the fence, but
I didn't measure it.
yeah.
We didn't either. We were going by the dimensions they
Yeah,
gave
okay.
us. So.
Any other questions for Mr. Paskey? Now you could come to the podium and state your name and address and tell us why you are building this and how big it's going to be, how two-story, and what's going to be used for.
Okay, so my name's Abby Rouse. I live at 20 Mulligan Road, and essentially we want to stay in our neighborhood, but our house is not currently working for us. We've sort of outgrown it. So what we'd like to do is add some additional square footage that would make our house more livable for us. And the entire addition would go at the rear of the house. There's nothing going at the front of the house, and so it really should not disrupt any of our neighbors' property lines whatsoever. It shouldn't encroach on any of their property lines. And basically what we're doing is the first part where our kitchen is, we would like to take that wall out and take that wall out 18 feet, and that would go approximately 12 feet the other way. And then the addition space would come off of that only 8 feet. So it's almost like an L shape. When we filed the building permit, we didn't realize that it would, be in violation of the city setback requirement. We'd like the variance just because we don't think it's going to cause any undue hardship to any of our neighbors at the time. I heard you guys had some questions about the drawings, so if I can answer any of those.
No, we got the drawings actually.
Okay,
Yeah.
you're good.
I guess I do have a question. Where you're putting the
the widest or longest addition, there's already a cement patio there, correct?
There is. There's a cement patio, and so the addition would have to, we'd pour the footers right beyond that. And so it's approximately 18 feet from the current back of the house, yes.
So if I could ask Mr. Paskey a question, if they already have that cement patio there, is that area not grandfathered in then?
Patios aren't, they can be, a concrete patio can be within the rear yard setback. Patios aren't part of the structure.
Okay, I'm just asking because a couple of weeks ago, we had that other guy who was going to...
That was going from a concrete patio to a deck, once again, two external items. They're not part of the structure. That wasn't part of the structure. This is actually part of
an
the house.
enclosed structure.
This is an enclosed
Okay.
structure.
So if I'm driving on Mulligan Road, looking at your house, I probably won't see this addition in the
You
back.
won't see anything.
Yeah.
That it will line up with the back of the house,
Right.
and the only people who will know that the additions
It's you.
are there will be us who are living there.
Yeah. Ed?
One of the criteria says there are exceptional or extraordinary circumstances or conditions applying to the property or the intended use of the property. What's extraordinary about your proposal?
I suppose that I don't know that anything's necessarily extraordinary. We love our house. We don't want to leave our neighborhood. So we would like to have the additional square footage. It's not going to disrupt our neighbors.
That was my question too. But any other questions for the appellant? Okay, you may be seated, depending on what these people have to say. Is there anyone who would like to speak on behalf or in favor of this variance? Please state your name and your address for the record.
I appreciate you just described. It's behind your house, right?
It's behind the house.
So we will not see, and then even see will keep the same color, right?
Everything will be the same.
Okay.
Sir, could you please state your name and address?
Okay. My name is Zhiyong Tian. I'm the resident at 19 Mulligan Road, just face to 20.
Okay.
So, and before I received the letter, so I also asked my other neighbors because he's in vacation. So we concern how the visible from outside if doesn't bother us, if cannot see it. Another thing I want to ask is what things will affect us? I'm not sure. Or something after the addition build up, anything will affect my property or anything?
I suppose there will be more children in there jumping up and down.
Well, no problem. We like children.
If anything, it's going to increase our property value, so I guess it would help you in that sense.
Yes.
So we'll increase our property tax?
No.
Oh, okay.
By the way, this was the portion that you would speak in favor of the proposal, but that's okay.
Okay. So I do not have any questions. Thank you.
Thank you. Anyone else who would like to speak, either in general or opposition? All right, thank you.
I can tell you, if you have this, I think you all do.
Yes.
The original plat before freeway came through here, you can see where there was a lot and the road come across, and this was actually called Oak Street, is what it was named. And when that came through, so we don't know if this was part of this. It's back before ODOT took it off, so it's very possible that could be your extenuating circumstances that their lot was reduced when ODOT came in and chopped in that property too. So I don't know I can't say it was, but.
Yeah, that makes sense, special circumstances, I think. You have a last chance to say anything you would like to say.
I hope you'll grant that.
Okay. We'll close the discussion from the floor. Any discussion?
I I guess I'm hung up a little bit on exceptional circumstance and undue hardship.
Well, I think one of the
I'm just trying to figure out, given other cases that we've had, what makes this one either unusually difficult or et cetera. So I'm willing to listen to.
Yeah, I think there is quite a bit of the property behind the house.
Yeah.
Whether, I don't know how much of it is a part of this, or maybe it's been taken off, but it seems to me that that at least visually will gives the distance to require 30 feet, and again, I don't know how much of it was a part of this property or was cut off, or is it city owns? There's never going to be anyone building back there. So in a way, we can justify that visually at least, they do have that 30 feet. And they are not in any of the city zone or line. Do you agree?
Yeah, the other situation I think is that the house is situated, and we've had another incident of this down on the west side, in the rear of the lot. So if that house would have been situated centrally on the lot, it's 60-foot frontage, they only need 25, then that to me is the exceptional circumstance making the backyards in the situation.
Well, my question would be the practical difficulty or hardship. That if we don't grant the variance, would we create a hardship for this piece of property to be used as effectively as it should be? So that's something we can discuss. Well, let's make a motion first by somebody, and then we can discuss it along.
Okay, I'll move that the board consider case 1506V, appellant Max and A.B. Rouse, 20 Mulligan Road, requesting a variance from ACC 231001, Table A, Schedule of Bulk Controls to allow an addition to a house with a rear yard setback of 12 feet, where 30 feet distance is the minimum requirement.
So we have a second. Should we just go through the findings? Well, exceptional circumstances, we just talked about it. Are we good on that? A practical difficulty and undue hardship because of exceptional or extraordinary circumstances or conditions pertaining to a specific piece of property, a literal enforcement of these regulations will result in practical difficulty or undue hardship that is unnecessary to the achievement of public purposes.
Right, so they have difficulty using the rear of their house space to expand because their house is sitting towards the rear of the property with 60 feet frontage. So to me, that's extraordinary circumstances.
And what about like the fact that the highway was put through that too? Was that?
Right. Well, it is a condition, but since we don't know for a fact, we do know where the house sits, and it's probable, right? Yeah, that the state took some of their backyards, so.
Is the house already utilized, effectively or efficiently?
Well, it is a family home in an R1 neighborhood, and will continue to be a family home in an R1 neighborhood.
Yeah, because
Another factor is you could say that the rear yard currently is only 23 feet. So that kind of proves a little bit that maybe there was some vacant.
yeah. Okay. Practical difficult, we just talked about that. Preservation of equal property rights. I don't think the general neighborhoods, they have the same situation as they do, so we are not granting any extra privilege to this piece of property. Minimum variance. The variance granted is the minimum variance required to make possible the reasonable use of the property. I think I added 720 square feet. Seems to be minimum. Absence of detriment. The authorizing of such variance will not be of substantial detriment to adjacent property and will not materially impair the purpose of the zoning code or the public interest, and hopefully it will not, increase the taxes on your property. Okay,
Not of a general nature?
it is not.
Okay.
Now, if we get a shot of everyone on the board from the control room, we would like to vote. Okay. Very good. Would all the members in favor of the variance please raise your hand? Okay, all opposing? You have your variance 5-0.
Thank you.
Thank you. Other business on the agenda is disposition of the minutes from March 10, 2015. I read it and I guess it was okay. Did you have some comments on that? No?
Well, I didn't, but I tried to look at the video, and I couldn't get the video because I have Firefox, and Firefox was having some problems on the videos, so I just solved that problem today or yesterday, and I didn't get a chance to, because usually go back and look at the video and look at the notes, so I guess I'll just move forward with the minutes.
So you're going to make the motion?
No.
I move to approve the minutes.
Second, do we have a second?
A second.
Okay. Minutes approved. Do we have a motion to adjourn?
No, we haven't approved, we haven't voted yet.
Yeah, we have to vote.
Oh, okay. All in favor? I knew everybody would. Now do we have a motion to adjourn?
I move that we adjourn.
Second.
So we are adjourned. Thanks.
Thank you for coming.